I would like to welcome you all to the last session, but not the last event, obviously, of the day. My name is Aris Georgopoulos. I come from the University of Nottingham. We know each other, most of you. So I have I am an academic, but also I have the more practitioner's hat of a consultant, particularly in context of reform of national regulatory systems around the world. Here we have a fantastic and hopefully very interesting panel. I'm sure it will be very interesting. We will be touch some points which they are very important, dealing with sanctions and debarments. Yesterday, Roger Bickerstaff has touched upon some elements of that with regards to the exclusion grounds of certain participants. And today we will focus much more on this topic of sanctions, and we'll look at the various instruments that they are available and how they are applied at international level. Before we continue, I would like to remind you all to fill in your forms, the feedback forms, that they are so important for understanding, for the organizers to understand what they have done well and what they can improve for next year's. And this has been a very useful exercise that led to the quality of the organization that we all enjoyed the last couple of days. So we will begin the presentation with Collin David Swan from the World Bank, and then we will follow with Jack.
That introduction, and I want to extend a very special thank you to Gustavo and Annalisa for inviting me to this conference. This is my first time attending this particular conference, and I have been very much enjoyed all of the conversations, the discussions, and getting to meet all of you and your different backgrounds and experiences. As Aris mentioned, I am from the World Bank, specifically the World Bank's Office of Suspension and Debarment. My office is one of 3 units within the World Bank that make up together the World Bank Group's sanctions system. And it is through that system that the World Bank uses to debar private firms and individuals from participating in development projects that the bank finances. And I'll talk a little bit more about that later. So my focus today is going to be on this concept of exclusion and debarment. And what do I mean by that? Sort of at the most basic level, it's a mechanism that is used to declare a supplier ineligible to access or to be awarded public contracts or to participate in public tenders. Jack will, in his presentation, discuss a slightly different set of sanctions, but still similar, same effect, that are economically and politically motivated. So before I talk about the bank sanction system and some of my office's research in national jurisdictions that employ exclusions, I want to talk a little bit about some first principles. You know, Roger, in his presentation yesterday, touched upon a lot of these points, but I think they are important to reiterate. They do help to explain and for you to understand many of the differences and similarities between debarment systems. So the first is one of lexicon. There are many different terms that are used across countries to describe this concept of exclusion or debarment. There is the term blacklist, debarment, sanction, suspension, exclusion, disqualification, ineligibility. Roger yesterday used the term deselection, which is one I hadn't heard of before, so I have to add this to the list. To give you some examples, Uzbekistan's exclusion provisions use the term blacklist. Debarment is used in the United States, Tanzania, Kenya. Sanction is the term that the World Bank uses, as well as Brazil. Suspension is a tricky one. It's usually more commonly referred to as a form of provisional exclusion. So a supplier is declared ineligible pending an investigation or pending the conclusion of a particular proceedings. Exclusion is the term that is used in the EU's Procurement Directive, as well as in New Zealand. So there are many different terms that show up in the legal frameworks all around the world. Generally, whatever the term that's used, the effect is more or or less one of two possible scenarios. The first is a supplier that is excluded from all or a set of public tenders for a specific period of time. This is a concept that I refer to as debarment. This is the classic debarment scenario. Generally, this will be accompanied by a public listing, though not always. In the World Bank's context, we do have a public debarment list. So when we sanction or debar a supplier, it is put onto the World Bank's website. You can go to it. It's worldbank.org/debar, D-E-B-A-R-R, 2 R's. And you can see all of the names. The second possible scenario is the disqualification of a supplier from a particular tender or procurement process, and that I generally refer to as disqualification. And that's what Roger spent a lot of time talking about yesterday. The EU's procurement directive really is more on a disqualification mechanism, where it's a contracting authority that on a contract-by-contract basis is responsible for applying the specific exclusion grounds. And this concept of disqualification can get a little tricky. I want to make clear that I'm not referring to a situation in which a bidder is disqualified because it failed to meet the specifics of that bid. In other words, your particular product that you were proposing didn't meet the technical requirements. That, for at least my purposes, isn't the scenario that I'm looking at. I'm looking at more, was there an exclusion ground? So if you look at the procurement directive, the 2014 Procurement Directive, a conviction for fraud or bribery, that is applied on a contract-by-contract basis by a contracting authority. So why exclude? What is a system, a procurement system, trying to achieve with this mechanism? There are many different purposes. The first is potentially risk mitigation, a forward-looking focus designed to protect public funds, to protect the government, to make sure that it is doing business with responsible, reliable contractors only. That concept is perhaps most prevalent in the United States' debarment system. In the Federal Acquisition Regulation, FAR 9.4, it makes clear that debarment should be used only for the public interest, for the government's protection, not for purposes of punishment. At the other end of the spectrum, punishment can be a reason to exclude. And at least in one jurisdiction that I'm aware of, Tanzania, its procurement rules state that punishment is one of the bases. It's to ensure compliance, that suppliers comply with its rules, to deter wrongdoing, and to ultimately punish those suppliers that do engage in misconduct. Other potential purposes involve deterrence, so deterring future misconduct, not only by the particular supplier that is excluded, but other suppliers as well as an integrity aspect, wanting to maintain public trust in the government. There is something to be said about setting an example, particularly if you have a public debarment list. It can be a way of making known that while it is impossible to catch all forms of misconduct, every instance of misconduct, that when misconduct does come to light, the government is going to take action and will act accordingly. All of that said, a system's purpose, if you look at any given system, it is not always clear. And in fact, very few laws, at least that my office has looked at over the last couple of years, explicitly state their purpose. Of course, you can oftentimes try to estimate or divine the purpose of a system based on how it is structured, how it operates. But I think sometimes it can be helpful, if there is an opportunity to reform or revise, or if you're implementing a system, I think this is step one. Think about what the purpose of an exclusion system is in this particular jurisdiction. What are you trying to achieve from a procurement standpoint, from an integrity standpoint, and so on? So that's the why. Now turning to the what. What type of conduct should a system exclude for? Roger talked a lot about the EU grounds for exclusion. There are many, many different forms of exclusion and grounds. They all are, depending on the laws you're looking at, worded slightly differently, or there's a long list, some have shorter lists. I generally try to lump these grounds into 3 categories. It is not a perfect categorization or system, but I think it helps to make sense of again, the reasons for exclusion. The first category is common integrity-based offenses. These are the ones that you, I think, would see most commonly. Fraud, corruption, collusion, coercion, bribery. I would include, anti-money laundering, terrorism violations. Potentially tax violations are quite common. Labor violations, we talked about health and safety in the previous panel. The second ground, or potential group of grounds for exclusion are what I refer to as capacity-related grounds. And so these are, for example, bankruptcy, which is a common basis for exclusion, as well as poor past performance or non-performance of a prior contract, if a supplier was terminated for default. This particular ground is of interest to me personally. I wrote a paper and did a bunch of research on this last year with a colleague of mine at the World Bank, Belita Manca, who's in the procurement unit of the legal vice presidency. And so we looked at the 15 jurisdictions that have poor performance or non-performance as a basis for exclusion. And we tried to look at exactly what does that mean, because I think unlike many of the other grounds for exclusion, poor performance or non-performance is perhaps one of the more subjective ones and more contextual. And then finally, we have miscellaneous grounds that you will see that are, again, very contextual, very based on different systems. 2 of the examples that I have seen in laws are failing to sign the contract and withdrawing the bid before award. In certain jurisdictions, those can be grounds for exclusion. So in addition to what is the ground for exclusion, there's a question as to what is the effect. What does that mean then if there is evidence of a ground? So if there is a basis to indicate that a supplier did engage in fraud or corruption, what happens? And in the jurisdictions, you see variations. There are automatic exclusions, which essentially mean if a ground is found to have existed, done. The supplier is then automatically excluded. Other types are discretionary exclusions, which would indicate that the decision maker, whoever that may be in the particular country or organization, has some discretion to consider factors. Maybe it's mitigating, aggravating factors, other considerations that might justify non-debarment or an alternative sanction, notwithstanding the existence of a ground. The United States is, again, another example of this. There are certain automatic exclusions. There are statutory grounds, particularly in the labor context, in which if a supplier is found to have violated this particular statute, they are automatically debarred for a period of years. But the more common example is the discretionary exclusion, which is most of the other grounds in the United States, where a suspending and debarring official, because the purpose of the system is protective and risk mitigation, is explicitly required under the rules to consider mitigating factors. Did this contractor, notwithstanding the existence of a violation, rehabilitate it? Did they take action? Did they address the misconduct? Have they reformed? Is there enough evidence of that? The European Union, has specific categories of mandatory exclusion versus discretionary exclusion. However, even in those contexts, even in a mandatory exclusion situation, there is the opportunity to self-clean. So in other words, notwithstanding the existence of a mandatory exclusion ground, a supplier, at least under the strict reading of the directive, can demonstrate to the contracting authority that they have self-cleaned, taken actions to remediate, to address the misconduct. And if that is found to be satisfactory, they will not be excluded. The third kind of element that I want to highlight when looking at grounds is how is a ground proven? Who gets to decide if a ground exists? In many jurisdictions, it is a court judgment, either a conviction, criminal conviction, or a civil judgment that serves as the basis. And that's true even in the United States. It's true for most of the mandatory exclusion grounds in the European Union's Procurement Directive. But there are, in some jurisdictions, an opportunity for administrative fact-finding. So the decision maker that is making the decision whether or not to exclude a supplier is making findings of fact, is taking evidence, is reviewing evidence. And that's true of the World Bank system, which is what I'm going to be talking about now. So as I mentioned, my office is one of 3 units that make up the World Bank's sanction system. We start with we have a separate investigative unit called the Integrity Vice Presidency. They consist of about 90 individuals who are charged with receiving complaints, with going out and investigating allegations of misconduct on bank finance projects and with bank finance contractors. And they put together a case if they believe that they have found evidence of misconduct, and they send it up to my office. My office consists of 8 people, 4 of whom are lawyers, and we review, our day-to-day job is to review these sanctions cases. So we act very much like a judge of first instance, if you will. We review the case, determine if there is sufficient evidence of misconduct, and if so, we will commence sanctions proceedings. And then the third unit is the World Bank Group Sanctions Board, which gives the respondent an opportunity to appeal and to contest those accusations if they so choose. So through this process, it is a quasi-judicial, it's a little bit more formalized than you may see in certain national jurisdictions. It's a process to, as I said, adjudicate these cases against suppliers that have been accused of misconduct on projects that the bank finances. In terms of the grounds, the types of misconduct that the system has jurisdiction to address, it is very limited. It is limited to 5 defined sanctionable practices: fraud, corruption, collusion, coercion, and obstruction. And those are defined in the procurement regulations, in the World Bank's anti-corruption guidelines, and are often incorporated into the bidding documents and contracts. Notice that one that was not included is poor performance and certain capacity issues. This is strictly an anti-corruption integrity mechanism. It is important to recognize also that the World Bank sanction system is an administrative remedy. So as was, I think, mentioned in the previous panel, the World Bank is not in a position to replace criminal authorities of any national jurisdiction. So these are solely for the World Bank's own purposes. They're administrative. The typical sanction that gets applied, as I mentioned, is debarment. And to be more specifically, it's debarment with conditional release. So what do I mean by that? It means that under the World Bank system, if a supplier is found to have engaged in one of those 5 sanctionable practices, they are debarred for a period of time, generally about 3 years, but it can go up or down depending on the existence of certain factors. And at the end of that period, the supplier is taken off the World Bank's list only if it has satisfied certain conditions to the satisfaction of the World Bank Group's integrity compliance officer. So the most common provision or condition that gets imposed on companies is putting in place some form of a compliance program. For individuals, it often involves training. And so the integrity compliance officer will work with the company, if the company or the individual engages, to ensure that they have satisfied those conditions, that they have put in place compliance, and then at the end of their debarment period, have rehabilitated. And so I think that's an important aspect of the system to keep in mind when you look at the World Bank's policy behind the sanction system, which governs, it was passed by the board of directors and is what sets forth sort of the reasons for the World Bank sanction system. Sanctions are designed to create negative incentives to discourage misconduct on our projects, as well as positive incentives to encourage prevention, remediation, and rehabilitation. And it explicitly states it's intended to deter but not punish. And other international financial institutions have similar systems. Another important aspect of how the World Bank operates, I think it's important to highlight, especially when you're looking at the World Bank system and you're trying to compare it to national exclusion systems. The first, at least in the context of how my office, which is involved in the World Bank's public sector financing. So the World Bank does have a private sector financing arm, but in the public sector side of the World Bank provides loans and financing to borrowing governments. And it is up to those borrowing governments to engage in the necessary procurements to hire those private firms and individuals necessary to complete the project, to build the roads, to build the schools, and so on. So what that means is the World Bank is not actually involved in the procurement. We're one step removed from the actual procurement process. We do require, as part of the agreement with the borrowing country, that the borrower will use our guidelines, our procurement guidelines, when entering into those procurements and those contracts. But it is through those contractual relationships that the World Bank has this right to investigate, to audit, and if there is any evidence of misconduct by those private firms and individuals on our projects, to ultimately sanction them. And the sanction, again, is a debarment, declaring them ineligible to participate in any more projects that the bank finances. So unlike the World Bank, if you look at national procurement systems, the national government is oftentimes the buyer or the end user. And so because of that, there's a certain different placement of the procurements that are happening, as well as the decision maker behind who is deciding who to exclude and debar. The other interesting, I think, difference between how the World Bank and other IFIs operate and national governments is that exclusion is often, in the national context, one of several possible remedies. So in the United States, my home country, a lot of debarments debarment actions are initiated after the conclusion of criminal proceedings or civil proceedings by the U.S. Department of Justice for fraud or Foreign Corrupt Practices Act violations. There is a whole other criminal side of the process that has different purposes. And so for that reason, the debarment system in the United States and in other countries doesn't need to sort of achieve those purposes. It doesn't need to punish. The World Bank, the sanction system, is really our only recourse. So one of the key questions that my office has been interested in for a while is really looking at how prevalent is exclusion in the national context. So the World Bank's two-tiered system, that 3 units that I talked about, has really only been in place since 2007. And we've started to see, and we've started to get requests from countries and government officials that are looking to reform their own exclusion systems or to implement an exclusion system in jurisdictions where one previously didn't exist. And so we started to undertake some research to really get a sense of what is out there, because unlike a lot of other areas, debarment or exclusion, there really hasn't been a lot of sort of methodical research into how it's used. And so we've begun two initiatives. The first is simply collecting as much information as we can get our hands on. So anytime we can get copies of procurement laws, of provisions that have debarment or exclusion sections in there, we try to capture them, we try to save them. We have a whole collection of saved materials, and then through that we try to analyze it. So we're just looking at what we can find. And then the second, which we started in collaboration with a working group of the International Bar Association, is a survey of global exclusion systems. And so the purpose of this was to sort of take that research one step further, to get a sense of, what is it like on the ground? How are these systems actually operating? We can read the laws. That's very, very easy. But at the end of the day, laws are paper. What really is important is how the laws are being implemented on the ground. And so we wanted to use this survey to get a sense of what is actually happening on the ground. So we initiated a pilot last year to test this survey to make sure that we've got the questions right. And we received responses from 11 jurisdictions, so 9 national countries and two international organizations, the European Commission and the World Bank. And we found some interesting things. The whole purpose, again, just to reiterate, of the survey was just to gather knowledge. So we were not looking to compare. We were not looking to rank or make judgments. We just wanted to gather knowledge and see what was out there. So we found that out of the 11 that we looked at, all but one, Australia, had some form of an exclusion system, or at least exclusion provisions. And so I use that term generally. The UK, some of the European countries, we said had an exclusion system because they had a set of exclusion provisions that applied across the procurement system. It's not the same as saying that they had a dedicated debarment decision maker and a public debarment list. The other interesting finding that we had was that all jurisdictions provided for some form of notice and an opportunity to respond. So the supplier who was faced with an action, an exclusion, at some point, the devil is always in the details, but at some point had an opportunity to provide its side of the story and to potentially appeal that decision. And as always, there's many differences across the systems in the particulars. Exclusion length, the grounds, process, whether or not there was a public listing, and so some of these differences. Who is the decision maker? What was really interesting is that in several of the jurisdictions, there were multiple decision makers. So depending on the particular situation, a supplier could be debarred several different ways or by several different entities. So for example, there could be a court judgment. As part of the court sentencing, a debarment could be imposed. There could also be an opportunity for the individual contracting authority to impose an exclusion or a disqualification. Certain jurisdictions had a designated official within each agency, a suspending and debarring official for that agency. And then other jurisdictions had a central debarring agency dedicated solely to these types of decisions. 5 of the jurisdictions had some form of provisional exclusion, which, as I mentioned earlier, is that suspension, sort of the declaring a supplier ineligible pending an investigation or proceedings. And that is generally a protective measure. There was enough evidence of an immediate need to get this supplier sort of off the list to declare them ineligible now while the investigation concludes. 7 of the jurisdictions did have a public list. The ones that didn't were Germany, Italy, and the UK, although I understand that Germany is implementing a non-public list in the next year or two related to, I think it's by the Competition Authority. So it's not quite a debarment list, but it is something similar. And then the last is that 3 jurisdictions did have some form of exception. So in other words, notwithstanding a supplier that may have been excluded, there is an opportunity or an option for the government to award a contract to that excluded supplier for a reason. So in Germany, it was for emergency situations. In the United Kingdom, it's public interest. And in the United States, it's urgent and compelling circumstances. So I just want to conclude with a couple of thoughts or considerations. If you are ever in a position to review an exclusion or debarment system or implement or reform a debarment system within your country, or maybe your country doesn't have a debarment system, but you're interested in developing one. What are some of the questions? What are some of the key points that you should consider? I think the first one is the purpose. What is the purpose? Is it designed to be a punitive system? Is it designed to be more focused on rehabilitation and protection? Similarly, is the focus going to be on past misconduct, or are you going to look more at sort of future capability? What is the balance between deterrence and fostering maximum competition? Debarment is a bit of a unique sanction in that you are reducing the available pool of suppliers. So you are reducing competition. In a market that is relatively elastic and there are plenty of suppliers out there, it may not matter. But for some more complex sectors, if you debar 2 major companies, there may only be 2 or 3 others left in the market capable of performing. So that's a consideration. Is suspension and debarment seen as a good result or a bad result, or is it neutral? I think very often we get questions around, how many debarments should we be imposing every year? Well, that's very contextual, and that depends. I think the number of debarments isn't necessarily an indicator of the function of the system. And then, of course, context matters. You can't take any one system and supplant it and transplant it into a new environment or a new country. It won't work. You need to take into account the local context, the local environment, the local capacity, consider whether or not there are other available remedies, or is it like in the MDB context, in the World Bank's context, is it the only available remedy? And again, in the World Bank's context and other MDBs, we often, have to address competing legal systems or competing backgrounds. And then there's a whole host, I'm not going to go into all of these, but there's a whole host of practical questions too to consider. You know, how are you going to set this up? What level of due process are you going to provide? Who's going to be the decision maker? What are the grounds? What's the evidentiary standard? And so on. So there's a whole host of other considerations which we can talk more about in the debate section. And then just a couple of available resources if you are interested in learning more. Thank you.
I would like to open the floor for a first round of questions. And I would like to give the priority to our students. If there are any questions for them, of course, we'll not oblige them to ask. Any questions? Yes, please.
I'm Ilham Yakubjanov. I'm from Uzbekistan. My question is about public listing of the department in a World Bank or other legal environment. Do you think if it's public listing is, available online, published for public, it's a punitive measure rather than self-cleansing? Because it can, if you publish it, it can harm the reputation of the company. Or if the aim would be just exclude the company from the tenders of World Bank, you can just provide it to the contracting authorities rather than to publish it.
It's a very good question. I think it's tough to answer. Is public listing in and of itself punitive? I think what is more important to consider is what is leading up to that public listing. So, you know, in the United States example, before a public listing happens, generally there is, not every time, but more often than not, there's an opportunity for the supplier to demonstrate that they are nevertheless presently responsible. In that type of situation, then it may be less punitive. You know, I have heard criticism of the World Bank system that it even though it's officially not punitive, it can sometimes feel punitive for the very reason that you just mentioned. It's public. A lot of different organizations and countries pay attention to that list. But I think, that collateral consequence, you know, is something that is considered. It's definitely not considered when we're making decisions on a case-by-case basis, but in terms of the effectiveness of the system and the purpose of the system, I think it is important. But it's hard to say, in the abstract, is public listing by itself punitive? I think it would depend on what is leading up to that public listing.
A general question. I was thinking about these principle in penal law that say that you cannot be convicted 2 times for the same behavior. So I was thinking, how can you be punished from the criminal side and at the same time be blacklisted? How do you find the same balance? Because someone will okay, maybe they had done a mistake and they are punished 2 times. Which is the correct equilibrium?
Well, I mean, depending on the jurisdiction you're looking at, debarment is a part of that criminal punishment. You know, so it's not that they're being punished twice; it's that they are criminally fined or put in jail and they're debarred. You know, in certain jurisdictions, it is the court that makes that that imposes the debarment. But I think even outside of that context, you know, it's a different. It depends, again, if it's a mandatory or an automatic exclusion. I think even if it's not imposed by the court, you could say that it is still nevertheless just seen as sort of an extension of the consequences of the criminal conviction. I think the question is a little different. If you're looking at the discretionary system where there are other considerations as to whether or not to exclude, then you're not really looking at a punishment, or at least you may not be looking at a punishment. And so there's a different considerations that will come into that calculus.
Thank you. Simple question. How you are dealing with the shadow companies? I mean, there's a list of sanctions on certain countries, different part of the world. Usually contractors, big companies create small or another companies to deal to get some contract with those country. How you, as a bank, as a World Bank, how you deal with those shadow company, and are you go after this company only or with the main company?
So that's the $1 million question, really. That I think is the most important. So officially, how the system works is if it's a company that we're involved, even if it's an individual. So I'll start with a company. At the World Bank, company is debarred. That sanction, there's a possibility for exceptions, but generally will automatically extend to all entities that that company controls. So it's downward flowing. The parent company or a sister company can also be sanctioned if there is evidence in the file of either direct involvement in the misconduct, in which case they are a respondent as well, or some form of failing to supervise or willful blindness, in which case then they don't necessarily get they usually won't get a debarment, they'll get some form of a conditional non-debarment. So they're still eligible, but they have to brush up on their compliance programs and make sure that they do have a system in place to supervise. The question, of course, is how do you identify the beneficial ownership, the corporate structure, and those are investigative requirements, and that it can be very, very difficult. And so if we know the names, the official sanction is that this extends to all entities that are controlled by both the company, and if it's an individual, any companies or entities that the individual controls. If we know the names, we will throw them up on the debarment list, but it is really up to the investigators to find that and to figure that out. And I think that is, in any system, that is probably one of the hardest pieces of the puzzle.
Thank you very much for your lucid and clear presentation that you have just given. I'm Moses Gebe. I'm coming from Sierra Leone, and we have noticed that the World Bank normally gives a lot of support to developing countries. Most especially in my countries, you are giving a lot of support. And interestingly, we've witnessed a lot of projects that are being supported by the World Bank, such that you have stages in which you approve and stages in which you say you declare a certain procurement misprocurement. Now, you have prior review to some of the projects that you give, and then you have the concept of retroactive financing, wherein you allow a contracting body or authority to undertake a contract. When they finished, they assessed the completion of the tax itself, and then you tend to review all the documents and then give a tranche of money with respect to that particular project, as the case may be. Normally, because you are farmed with the procedural rules of your laws and everything, sometimes you will realize that a country must have undertaken a contract and completed that contract, and then when you have realized that they have not followed some of your rules, you will declare that contract misprocurement and you will not pay. In circumstances like that, haven't realized that the project has been completed, why do you actually go in that direction? Is there any way? Because if you begin to assess the project based on the agreement itself, you must have clearly indicated in the agreement that this is going to be a post-review contract or a prior review. But you sometimes, when you base the contract on a prior review, you wait, the contract is finished, completed, it is accepted by the community, and then after you want to review it, as long as they've missed the point of your processes, then you declare that misprocurement. It has happened in my country. It has also happened with projects that I've handled. So how do you actually handle such situation? Thank you.
It's a good question. It is. It's one that is dealt with primarily by the operations teams. So it's not within my wheelhouse or within the World Bank Group sanctions system. So we don't deal with declarations of misprocurement. That would be the procurement units within the bank or the specific task teams that are involved in those specific projects. And so, a declaration of misprocurement, my understanding, again, this isn't what I do day to day, is a declaration that the bank will not finance that particular contract because the borrower did not award that contract according to the bank's procurement rules. That's sort of my general understanding of how that works. That's different from the sanction systems focus, which is really on those private firms and individuals that have been contracted. Did they engage in any form of misconduct either in the award, the procurement phase, or during the contract execution? So, and we do get cases sometimes that
there was a poor development outcome, but it may not have risen to the level of sanctionable misconduct, right? There wasn't fraud or corruption, it was just incompetence. Or there was a procurement failure because the contract wasn't clear or the bidding documents weren't clear as to sort of the specifics. And so, I guess the only thing that I can say about that is that a declaration of misprocurement does not necessarily lead to a sanction effect in the system. So there may not necessarily be an indication where my office or the other units that are involved in the sanction system would get involved in that situation.
Just a very brief one on the goals of debarment, which is important also, I imagine, for empirical purposes. Once you know the goal, then you can work on the empirics and see if the goals have been achieved or not. Now, I don't seem to understand why do we have to talk about punishment or punitive? Unless you're a sadistic being, punishment is not a goal. So I would refer certainly to deterrence as a goal and then measure it empirically, or another one, which is you mentioned, which is what happens in reality when we put people into jail, prevention of reiteration, which also explains why we have self-cleaning on the other hand. But I do not put punishment in the same category of these two as a third goal. Am I wrong? Am I right?
I think it comes down to sort of what are you looking at, and what do you. It's a very good question, and it's an important one, even if it can sometimes feel a little bit academic. But I think it comes down to sort of. So punishment is in criminal law. So I'm looking at the United States, which is my background as a lawyer. Criminal law is designed. It's very much backwards looking. You committed an act that was wrong. So we are going to impose consequences on you for that act. That can have a deterrent impact in terms of we want to make sure that you don't do this again, but also we want to make sure that others see that and don't emulate you. But I think the deterrent effect only works if there is a possibility that you may do it again if you don't engage in consequences. And I think it can start to feel more punitive if there isn't that opportunity to demonstrate, I learned my lesson, this was a mistake, I'm sorry, I won't do it again, here's my proof for why I'm not gonna do it again. Do you still need to take that action? I think another example of where debarment can feel punitive is particularly in the flat term debarment, the fixed term debarment context, right? So you're debarred for 3 years. You engage in a misconduct or a sanctionable offense, some form of ground. You're debarred for 3 years, and then after 3 years, you're off the list. Is there any consideration as to how you may have reformed, any changes to your behavior, or is it simply you're put in timeout for 3 years? You know, that, I have a very young son, so we haven't gotten to the timeout stage yet, but you know, it feels kind of like you're gonna be put in the corner and then learn your lesson, but you could also just wait it out and say, okay, after 3 years, I'm gonna go back to doing exactly what I did before. Maybe a little more carefully so I don't get caught next time. So I don't know if that answers your question, but it's a very interesting.
Thank you. My name is Kenneth from Swaziland. I just wanted to ask one question. Have you met a case whereby you made a mistake, like you sanction or you debar somebody with maybe misjudgment, or maybe not all getting all the facts?
I hope not, but we're all human. I think that specific risk is why the system is designed, at least at the World Bank, is designed the way that it is. So, you know, I didn't go into specifics about the mechanics of the procedures, but the investigators go out and do their investigation. They almost always will issue a show cause letter to the respondent before we even see, my office even sees the case. So there is at that point an opportunity for the respondent to present their side of the story and their evidence. And then the case comes to us, we review it. We then, when we issue a case, when we start proceedings, we send everything that we looked at, all of the evidence, we make a copy of it and we send it to the respondent. So they see exactly what we've looked at in our determination. They have an opportunity to submit a written response to our office. They also have an opportunity, if they wish, to appeal to the Sanctions Board, which would provide for additional briefing and more an in-person hearing, even if they choose. And there are times where we said yes to a case, it goes up to the Sanctions Board, and they have found insufficient evidence because of new factors. There have been a couple of times where at the explanation stage, when the respondent submits its filing to our office, we look at it and we say, you know what, you're right. This changes the full calculus, and so we will withdraw the case at that point. And so I think it explains the need for due process, right? This is why we have that system in place, because we want to protect the bank. We want to make sure that the funds are used properly, but we also want to make sure that we're not being overzealous and sanctioning sanctioning firms and individuals that didn't engage in misconduct.
Great. So we
well, actually, what I wanted to say was that in the IFI context, since we are here sitting World Bank and the EBRD, a discussion about debarment wouldn't be complete probably without also mentioning the cross-debarment system that we have. And you mentioned in your slides that the fact that we have very similar system looking at debarment in most of the banks, but we also have amongst some of the banks, not all of the banks, but in some of the banks we also have the cross-debarment agreement, which means that if the World Bank debars a company for more than 1 year, it will almost automatically be debarred by the other banks.
And that's another consequence of the public listing too, because it has to be a public debarment as well.
Exactly. And the interesting thing is that we've been talking about the COBRA effect, the law of unintended consequences, and this is also one thing which sort of had compounded to that, and that is the fact that we are trying more and more to do joint co-financing, and we work on joint co-financing agreements, mutual reliance agreements, etc. But the interesting thing is that this has created also a situation that a company can be debarred by one bank below one year, and then does not become debarred by the other bank automatically because it's under 1 year, which means that we might end up with a situation there where you have debarred one company and we have not debarred the same company, but we wouldn't be able sometimes to debar because the grounds for the debarment is not supported by our policy. So we do get some weird situation. Now, talking about weird situation, I'm going to move up and stand there. As you know, I'm famous for the weather. I continue to do my fair share of that, exactly. Right, I'm going to throw myself into real deep water with this presentation, because at the end of the day, unlike Collin, I am definitely not a sanctions specialist, But I am a procurement specialist, and as we have been talking about in our classes many times, for me and I know for most of you, procurement is really project management. It's about linking all the disciplines which are necessary to achieve the objectives of the contract. It means that we are working with our friends in the environmental health and safety departments. It means that we are working with our friends in the integrity offices, our engineers, our economists, our lawyers. Everything has to come together in order to have a successful outcome of the contract. I think that is extraordinarily important. And that means that we are really in the melting pot of various policies, and we are, at the end of the day, sometimes, whether we want it or not, we are the ones who are ending up with situations in our lap, even if it may not be directly under the procurement policy, but are reflected in other policies. And this is exactly why I wanted to talk a little bit about sanctions. And this is the first time I'm ever doing a presentation about sanctions, so I just want to warn you that if it goes astray, help me out. Yeah. But point being, I would like to talk about this because for me it is very clear, and it's become very clear the last 3-4 years, that economical and political sanctions are going to be creating more and more issues for us in the field of procurement. And that's why I think it is important that we raise this issue, have a discussion about it, and ensure that we can address it in the correct way. And just to if I can make the slides work, yeah, to dwell upon what the sanction is, you know. You were talking about that there are many different sort of definitions, yeah, and this is actually very, very true in terms of the overall view of sanctions, you know, because we talk about sanctions and debarment, and sometimes we talk about debarment as part of the sanctions, whilst at the end of the day, the debarment, it's more focused on when you have done something which is, let's say, against integrity practices, good integrity practices. Yeah? But also, and this is coming from me searching the internet, coming up with something interesting to say in this context to start with, the fact that the word sanction is a word which is auto-antonym, which means I can sanction something because I think it's good. I give you a sanction to do that because I think it is good, but what we are talking about is obviously the opposite way around. We sanction firms, entities, and individuals because we believe for one reason or another that this is in our interest, yeah, or someone's interest. Yeah. And I also came across very often in my little internet research that sanctions are defined as a lower cost, lower risk, middle course of action between diplomacy and war. And I think that is really rather telling what we are talking about, because sanction actions in itself can also lead to quite intricate situations between countries and also institutions. Yeah. So what I wanted to talk a little bit about, and I wanted us to have a discussion about this. I think this is important. It's not only about me talking. I want to raise the issue, and I would like to have a discussion about this. You know. So economic sanctions, though, typically ban on trade with tariffs, quotas, embargoes, non-tariff barriers, etc., like onerous regulatory requirement, which is also one way of making sure that you make it difficult for a company from one country to participate in another country. You know? And this is the ones that you see in bylaws, etc., in processes applied, which makes it impossible for foreign companies to participate. You know? Political and diplomatic sanctions, which can be unilateral, meaning that they are imposed only by one nation, or bilateral, meaning a bloc of nations. Yeah? And international sanctions, coercive measures adopted by a country or a group of countries against another state or individuals in order to elicit a change in their behavior. And one example, which we all know that are working in IFIs, that is applied by most of the IFIs, is the adherence to, or I would say all the IFIs plus financing institutions such as EIB, is the adherence to the UN Chapter 7. Yeah? Because the UN Chapter 7 is obviously supported by all countries which are UN member countries. Yeah? And that is very important. That is the basic reasons why we can all adhere to this without problem. This one came across also, according to studies, sanctions have only a 30% chance of succeeding. And this might be good to know for some of our political friends out there. And I think one very important reason why this has sailed up very much in the last 3-4 years, in my opinion, why we see it more, let's say, affecting procurement, is because of what we see generally in the society, in countries, the more, let's say, protective views, and we are the best, no one else do it as good as us, and therefore we exclude others. So the very political motivation behind, but do it actually achieve what you want it to achieve? Another thing which is pretty clear is that the longer sanctions are in place, the less effective they become as the target nation or individual learn how to work around them. That may not work so well when it comes to debarment, but it may work different when it comes to politically and economically motivated sanctions. A good example of where sanctions actually at the end of the day achieved its objectives was probably South Africa, which at the end of the day was a long and very broadly supported sanction against that regime at that time. Yeah? And obviously sanction against country, state-owned or private entities and individuals. It can be against any of these forms. Yeah? Now, examples, and I apologize for my pronunciation, but this is OFAC, the US Treasury Department, so it's an acronym for the Office of the Foreign Asset Control. And this is something that we as banks are being more and more exposed to nowadays, because this sanction makes it very difficult for banks and clients to effectuate payment. So that is really a very, very potent problem for us. And then we have the EU, which calls restrictive measures, which are imposed by EU to bring out change in policy or activity by a target country, part of a country, government entities or individuals. So the broad span. And the interesting thing there, I think, is that when talking with our friends in EIB, they obviously apply the UN Chapter 7, as we all do as IFIs, but they also, even though it's not in a public domain, apply the OFAC regulation. And that was a little bit of a surprise to me. And I've also been informed that the Inter-American Development Bank, which traditionally have followed exactly the same as the rest of the banks, have also now officially said that they are going to follow the OFAC regulations. Rather surprising to me, but that is what I've been told. Another type, which is the Arab League boycott, which was originally designed to weaken Jewish industry in Palestine and to deter Jewish immigration in the region. Now, this is also something that affects us. We work in the let's say Northern African countries, and we also work in Middle Eastern countries. Yeah? So there we have seen as an example, for instance, that clients have refused to accept, let's say, experience provided by companies that are based on them having successful experience in implementing a project, for instance, in Israel. Yeah? So that project as an experience, making the company qualified, has not been accepted, just because it was done in a specific country. So that makes it very difficult. It also, the Arab League boycott makes it very difficult for us in the sense that if we want to do joint co-finance projects with the Islamic Development Bank, then the fact that they have to apply the Arab League boycott regulation means that it's very difficult for us to do the joint co-financing. That, however, has just recently apparently been softened up as a firm requirement with the recent procurement reform that the Islamic Development Bank has gone through. We have not yet had a possibility to test it, but it would be very interesting if we can do that. Yeah? Then we have the unilateral sanctions, which are imposed by individual countries to further strategic interest or to penalize, as an example, for hostile actions. Yeah? And there we can see, for instance, in Ukraine, just make that as an example, where there is no embargo, no sort of national embargo towards Russia, but there is a very extensive list of Russian companies and individuals that are based, which are placed on this sanction list, which again makes it difficult for us to act. In terms of embargoes, national, again, country against country, we actually have an opportunity to accept that, but we cannot accept when there is a politically motivated list for firms, individuals. So that makes it, again, very difficult. Another example of that is Turkey, where before the coup there was in the sort of lower region of the thousands on their sanction list, which was not based on integrity issues. And after the coup, this list has grown enormously, and now we are talking about the number of tens of thousands of companies and individuals which are on this list, which again provides, or let's say, forms issues for us as IFI. Then we have the UN sanction, which I talked about before, which obviously has an extraordinary strong international, let's say, based on international law backing, and that is why also banks like ourselves can comply with this requirement. So, what happens if you don't comply? Now, I'm just taking the OFAC regulation as an example, and these are the penalties that can be applied if someone, individual, organization, country, would not adhere or actually, which I think is very important, if someone knowingly making false statement or falsifying or concealing material facts when dealing with OFAC in connection with matters under its jurisdiction, that is a criminal offense. It means, at the end of the day, that if you are abating and supporting activities which avoids the application of the OFAC, you are actually putting yourself and potentially your organization in a very difficult situation. I happened to speak last week with a person who worked on, let's say, with this from a legal point of view, and he was very worried about this because he is now actually working on procurement side, but he was very concerned about activities which are happening in order to avoid OFAC regulation, such as switching currency for a contract, etc., because he said that I know how the system works. I know that I will, if this is being detected, I might be actually apprehended at the border control in the US, and I might find myself as an individual in a very precarious situation. So he was really concerned about this. So I just wanted to say, at the end of the day, when we are dealing with these issues, even if we are trying to do our best to make sure that our clients are able to work with the contractors and implement the projects, when doing so, we need to be very, very careful in how we do that. Also interesting, if you look at the OFAC regulations and you look at our bank, what are the countries, from a country point of view, which are affected by this regulation directly as countries? All the Balkan regions, Belarus, Iran, as we all know, Syria, which is very important for us to take in consideration. Now, looking then at our policies, and again, we are very similar, most of the banks in this respect, when we look at the economical and political sanctions. So these are the three policies that Evgeny, Marita, and everyone working with procurement in EBRD are responsible for, and the one in blue is our procurement policies and rules. And those procurement policies and rules, they are really an extension of the article of agreement establishing the bank, which contains a number of provisions which guides how we should look at procurement. What kind of key principles that forms the basis for the procurement policies and rules that we formulate and follow. And in this context, I thought it was important to bring out that the articles of agreement established in the bank says that the bank shall place no restriction upon procurement of goods and services from any country, from the proceeds of any loan, investment, or other financing undertaking in the ordinary or special operations of the bank. And with special emphasis on other financing. I think that is also very important in this context. And then in the procurement policies and rules, paragraph 2.6, and I'm sorry for reading this, but I think this is important. Any conditions for contract award shall be limited to those that are essential to ensure the eligible firm or individual's legal, financial, commercial, and technical capability to fulfill the contract in question. Clients of the bank will not exclude the firm or individual from participation in a tender process or contract award for reasons unrelated to his capability to perform the contract, unless the firm or individual has been declared and remains as the relevant date ineligible pursuant to the enforcement policy and procedures, exactly what Collin has been talking about so far, has been convicted of an international crime, or is prohibited under relevant national law from entering into commercial relationships with the client, meaning EBRD client, provided the prohibition relates to a prohibited practice which has been determined through judicial or administrative proceeding with adequate due process acceptable to the bank. Very similar language as most banks. However, from a procurement point of view, I would have been very happy if it has stopped after the comma. Is prohibited under relevant national law from entering into commercial relationship with the client. That would make my life easier. It may not be politically so correct, but it would make my life as a procurement person easier, because that means that I could take into account sanctions, which I cannot do at the moment, or clients can have. So the one about political sanctions then is paragraph 2.7. Consistent with international law, the proceeds of the bank loans, equity, investment guarantees and grants shall not be used for payment to person or entities or for any import of goods if such payment or import is prohibited by a decision of the United Nations Security Council taken under Chapter 7 of the Charter of the United Nations. Now, has anyone looked through and try to find out if a company is covered by the Chapter 7? I got a hand there waving in the wrong direction, but has anyone looked at it? You are? Okay. Yevgeny has, I know. Yeah. And did you manage to find out if that company or individual was actually covered by UN's Chapter 7? Edward? No, exactly. It is very hard. You need a lot of interpretation and support to be able to see if they are actually covered by this Chapter 7. Very difficult, in my opinion. We have discovered that one good way of finding out if they are actually covered is to go into the UK's interpretation of this because UK has drawn up a list of companies, countries that are covered currently by this Chapter 7. But failing to, or let's say, not looking at that list, it's very hard to find out. Yeah. So these are our own regulations as banks. Now, I have put up some topics for discussion, which I thought that we should go through in this context, because I'm not going to provide any solutions and answers to this, but I want to have a discussion, because in my opinion, it is way too early to be able to say how we as IFIs are really going to deal with this. One of the things that I've been pondering and discussing with our legal department, and I've shared with my fellow colleagues in the other banks, is to talk about the clause that I previously referred to, meaning whether if you are under a sanction, you are actually legally capable of performing that contract, whether that could be a way out in order to avoid the discussion which is highly political, whether we should adhere to the OFAC sanction, the EU sanctions, or national sanctions, etc., whether that can be used. Again, a very difficult topic, and we have no answers at the moment, so no solutions. So, topics for discussion. And I'm going to actually do like this, that I'm going to use, do we have the that one, yeah? Just to make sure that we spend the last 10 minutes on actually discussing this, I'm going to take them one by one, and I'm going to stand out here so it makes it very easy for anyone to pick up on the discussion from the audience. So the first question, do all the IFIs apply the same sanction regimes? I have already answered that question. No, we don't. The traditional, let's say, development banks, by and large, we do. But when you go into sister organizations like European Investment Bank, you start to see that we have differences. I already mentioned that. I also mentioned Islamic Development Bank, which has a slightly different approach to this. So, yes, we are different, yeah? And let's see. So, if not, which is the case, what are the consequences for mutual alliance agreement? This is something which is very important for us nowadays. We are trying with all the banks that we are potentially doing joint co-finance projects with, we are trying to find a way to make sure that we can operate as efficient as possible in this joint co-financing arrangement. And that means that we are relying on the other bank to apply an agreed procedures for procurement. Agreed procedures for procurement. Yeah? And that means that we can hand over to someone else as being the lead financer instead of both banks being involved if we have a joint co-finance contract, so we can hand it over. But other policies, such as integrity policies and sanction policies, environmental policies, has to be adhered to. And how does that affect the mutual alliance agreement? Any takers? None at all. Okay. Nothing?
May
Yeah?
quickly throw in something?
Yes?
So, what you say about the same sanction regime, you mean also in terms of the type of sanctions that they are meant to be, whether they're mandatory or they can be discretionary, or do you also refer to the other ground implied standards? Because we had a very interesting conversation yesterday with Collin,
Yeah.
in the context comparing not so much IFIs but countries with IFI regulation, and we refer to the standard adopted at federal level in the context of the foreign corrupt practices in the US that finds not problematic, allows payments from US companies to officials in third countries, not payments that they are not aimed at giving them unfair advantage, but they are payments to incentivize these officials to do their work. Now, if we compare that standard, right, which is koshered, right, it's allowed, with the UK Bribery Act, that's not allowed. So you see, in the same, and yesterday with Roger, we discussed about extraterritorial application. We see that the underlying standards are different, and then we have, in one context, absolutely legal and lawful conduct, and in another region or jurisdiction, the very same conduct could lead to debarment, could lead to other sanctions.
Mm. No, my point here is going back to what we talked about before under the debarment system, where in fact, even though we have cross-debarment, we are still not debarring all the companies in the same way. Now, what kind of effect does that have on procurement? It works in the same way with the sanction, because if we do not accept, let's say, OFAC or the Arab League sanctions, if we are in a co-financing situations which are becoming more and more important, what kind of effect does it have on procurement? What kind of problems do we face?
And I think there's a similar consideration that I've heard from some procurement colleagues at the bank relating to borrowing countries that would like the World Bank to recognize their national debarments. And the World Bank generally, there is a technical provision that could allow that if the debarment was based on fraud and corruption and there was due process. But for the most part, there is no recognition of national debarments by an IFI like the World Bank. And part of the reason for that is again, sort of what's the purpose, what is the underlying standard? There are risks that debarments at the national level could be political for whatever reason. So I think there are many, it's the same consideration, but in many different.
Exactly, which is exactly the same reason why I posed this question. What should tender documents state about sanctions when using national procedures or local competitive tendering for contracts financed by an IFI? Because if we look at the standard tender documents that we by and large are very harmonized between the banks, then there's the provision in there very clearly state, if you are found on, let's say, the World Bank's debarment list, you are not eligible. If you are covered under UN Chapter 7, you are not eligible, and that's what we are saying. Yeah? Now, if under local competitive tendering, which just to make it absolutely clear, I think we have been discussing that in the, let's say, in Torre Vergata, which is different from using national procedures, because local competitive tendering basically means that you have agreed a set of procedures that are applying during a tendering process, and you have agreed on a document that is supposed to be used under the tendering process, which does not necessarily always, let's say, supported by national law. Yeah? Point being that as banks, we don't like preferences, etc., you know, and that cannot be reflected in the tender documents, even under local competitive tendering. But my point here is that if you apply local competitive tendering and you do not state that national procedures are not acceptable, if you don't specify that specifically, will companies that are covered by national procedures actually ever bother to apply? What do you say? Edward.
Which has its own sanctioning prescription or something, it should be reflected in the particular conditions of contract. If it is not reflected, of course you cannot apply. But the best scenario is to reflect, and like in Armenia, we have our Ministry of Finance, they have their own procedure and own sanctions, sanctioned companies list, which is updated monthly, evenly, and distributed to all PIUs, to all executive agencies, and posted. So, if you put in the particular conditions, it works, and
okay.
It's okay.
As you know, that most of the banks, they are working with the sovereign lending, yeah? When it comes to the public sector projects, where the notion is that once you sign a sovereign agreement, all the laws and regulations of the country are superseded by the legal agreement with the country. Yeah? Now, the question is, does that actually, at the end of the day, apply to the contract law? Once the client is in the situation of actually signing the contract, where contract law kicks in instead of the procurement laws, yeah? Does it really apply? Can you do whatever you want to as IFIs under a contract governed, which very clearly in the contract says this contract is governed by the law of Ukraine, Belarus, whatever, that country where the project is. So does it actually supersede? And to compound that question, in our case, we are working with sub-sovereign lending, which means that we are providing public sector loans which are not guaranteed by the government, which do not enjoy that sovereign agreement. Can you actually go out to a state-owned company and say, you actually have to apply, let's say, procedures which are not supported by your national law? The reason why I'm raising this, because this is exactly what we are talking about when it comes to the national debarment list, etc. Can you actually force a client to sign a contract, or let's say to sign a contract with someone who is on the, covered by the national debarment list, national sanction list, but not by the IFI list?
It was international conference, and they lifted sanctions related to science, sport, and airplane. I went there, and after dinner, next day they told me that still I am under the sanctions, because the terminology of University of Tampere, how they were interpreting that, and the Council of Europe was different. So I'm speaking about another topic, but this is the same topic. And then I said, what those sanctions means. They said, I said, should I go? They said, no, you can be here, but you cannot present your paper, you cannot put questions, and you cannot give answers. After that, all participants realized that dinner, where we were discussing about everything, was the last dinner, and that it was only hi, how are you, and so on. And there was a meeting at the city council. I was, of course, alone. And then, it was not by coincidence, one man from Sweden approached me and he asked me, what is your system? And I explained him our system, Swedish system, because it was my master thesis. And I said, after 2 minutes, please, I have to warn you. You may have some negative outcomes because you are standing with me. He said, no way, I don't care about this. And so sanctions were lifted, and he was asking me to give him his paper. I said, this is illegal. And he said, I don't care. So what I'm telling, first of all, what you said at the beginning, political aspects, especially we are speaking about public procurement, should be reduced as much as possible. It should be connected only with, let's say, something that was the common decision. Second thing, it is for lawyers and for everyone. Legal safety is crucial. So it means whatever is the solution, because as you mentioned, between IFIs there are differences. So one way is to work on some standardization about some mutual agreement, or at least what is the minimum requirement and so on. But if there is no consensus concerning certain issues, it is necessary to specify exactly which rules are going to be implemented. Also in national laws, you know that provision that in this and that cases, international rules will be applied. So to avoid any misinterpretation or confusion, it is crucial to exactly define which rules are going to be applied, and to work, of course, on this standardization, because if we are at the global conference, globalization was one tendency. Now we see the opposite tendency in a different ways. It's like centralization, decentralization. So we are in changing environment, and fortunately we are creative. So we have to find solutions for the period that is coming. Thank you.
Exactly. And I'm going to finish now because it's 12 o'clock, and that is the end of this conference before lunch at least. But I'm going to pose this question anyways, because and I'm going to quickly provide an answer here. This is the last point. An IFI client evaluates a tender, and the lowest evaluated tender is an Iranian company. We work a lot with, or we have a lot of Iranian companies participating in our tenders. The company is using an Iranian bank for the tender security and for its company account. The bank is, during the evaluation, put on the OFAC list. Not the client, not the contractor, but its bank. Now, the first thing is then, what happens with the credit rating of that bank? And one thing is that we are not going to be able to effectuate payment, for sure. So what kind of effect does that have on the contractor's ability to actually perform under the contract if he's not getting paid. Unless obviously you take a big bag with money and cross the border if you manage every day. Yeah? Now, one thing which is important here, and that this is mostly for those who are working with the IFI procurement, and I think it's very important for us, and that is that if you look at again, the standard tender document that most of our banks are using, and you look at the requirements for tender security and performance security, then it states that first thing, it should be from a reputable bank. Now, if anyone can give me a quick answer what reputable bank is, I will buy you a dinner tonight. Second thing is that it does give you an opportunity to specify the credit rating of the bank to be used. You know? But that is not mandatory, but we will change that. It has now to become mandatory, because the point is that if you are covered by any one of the sanction regimes, it's not a question about reputable anymore, it's about you lose your credit rating. And that is a way for us as procurement specialists to say you are not now supported by the requirements in the tender document. I will finish with that. Thank you very much. This was just a test. I hope that you will think about it. It's very important.
With all respect to you personally and what you have wrote. The paragraph 3, yes. Yeah. So as Arab countries or as a Muslim community, we are not against any religion or anyone, especially the Jewish religion. We are dealing with them in equal treatment. But we have also, yes, we do have problem with the state of Israel, yes. So destroying or weakening the Jewish industry, I guess it's wrong.
That is
with all respect.
Yeah, that is taken directly from the definition, because what I was saying was that that was the origin of the it's not anymore.
I'm not sure. I don't, but
okay.
I disagree with it.
No,
because
I take
large
your point.
Community,
Yeah.
Jewish community are living among us in Morocco, Algeria, and even in Yemen now, where there is a war right now. There is large Jewish community living with us. Mm-hmm. Even in Lebanon, we have a few, but they are living with us. We respect our religion. We have nothing against any religion, especially the Jewish. And one hand, when you know, most of the Muslims, when they are flying abroad, they are looking for halal food. Yeah. So one of the suggestion or recommendation for them is go for the Jewish stores to buy your own food. So we have nothing against those people. Thank you, and sorry for...
I agree with you, and thank you very much for providing that clarification. I think it's very important. I did take this directly from the original explanation why it was originally set up, and that's how it was specified at that time. It has since then very much evolved into something different, you know. But this was what I took from internet, so I blame the internet.
Yeah. Please. So, very, very important clarification. Yeah. I think we all agree on that. So, first of all, 2 points. I would like to invite you all to to show our appreciation for a very, I think, thought-provoking discussion. Very interesting. A fitting sort of culmination of today's conference. And I would like to invite Gustavo for a final announcement, I think.
I want this last slide because we have an expression in Italy which is probably exists everywhere in the world, which is chiudere in bellezza, which means close with beauty. For a university professor to have the last slide of a long conference ending up with a question mark is the best sign of success. I also wanted to say that these slides represent a little bit, first of all, the importance and complexity of procurement, which is basically, as we heard from these past two, especially this last one, which was very brave by Jack to undertake and challenge us with, at crossroads with politics and at crossroads with the global ethical dilemma. And I think it was never as clear as with Jack's presentation. But also I was thinking about what was this fourth edition of GPC all about. And I think that we certainly have given no answer, thank God. But there was an undercurrent in all of these 2 days about the fact that we should think always, every day, about what is good procurement. because we always say we should have good procurement, but I think that what emerged, maybe we knew it already, is the several dimensions that this word good has, and constitute part of our job to always debate about what exactly is good procurement. And all the presentations that we have heard over the 2 days have, in fact, given various interpretations of what is good procurement. And I think it's one of the contributions of today, of this conference. Finally, I wanted to say that, again, in line a little bit with Jack's desires, for next year, we're going to consider, you know, we have the 30-30-30 rule, which is not only about professors, consultants, and institutions, it's also about the minutes, how we divide the minutes. 30-30-30 is 30 minutes to each speaker and 30 minutes to the public. What I have sensed, but I was talking with Annalisa about it, and we'll talk also with relevant stakeholders of GPC, is that a minor change, like something like 25, 25, 40, might be even great, because I saw that every single session ended up with people wanting to ask questions and not reaching the final stage, which I think is really a proof of success, and I think it should be cultivated. I'm sure that the same good presentations, let's think about it, but that same presentation can have the same caliber of quality with 5 minutes less. But at the same time, what we learn from the question is, I think, really the most important part of our project, and that we give so much time to people in the public. I think it's a unicum in these kind of conferences, and so maybe we will discuss with the EBRD and Tor Vergata about this, which leads me to say, in this review process, if you dare going out, quitting those quarters here this afternoon or now, without having answered the questionnaire, you're not going to be able to go out. You're going to be checked everywhere. 2 more things that, actually 4 more things that Annalisa wants me to say. Yes, JPC hopefully is going to happen next year again in July, first week, but we're going to be very quick in trying to put a save the date out so that you can immediately write it in your agenda for 2020, hopefully. I also wanted to say that it seems almost certain, and Tor Vergata is very honored about this. Again, you know that we have a second event, which happens more rarely than JPC. It's called the Interdisciplinary Symposium. The last one was in Paris last year. We typically strive to do an agreement with a prestigious university outside of Italy to co-produce the event. And I'm glad to say that it seems almost 99% likely that the Higher School of Economics in Moscow, in Russia, a very prestigious institution which is very famous for its scholars in public procurement, has accepted to co-share the event with Tor Vergata. It would be the end of September. Again, September, obviously 2020, not 2019. So we will give a save the date on that one too. There's going to be a call for papers, obviously, where you are invited to join, as you have in the past, as alumni of the master or else. Finally, speaking of masters, two very important information. Belgrade 3rd edition starts in October 2019, correct, Bata? And IMPPM 8th edition starts in March 2020. This is a very private and internal message, especially for the master students. Please, please, please send the news out. We need good applications. We need good applicants in your country. You know very well what IMPPM and the Master of Belgrade stand for. So you know the quality, you know the requirements, you know what kind of people we want, you know the passion that we want in people. It's not just about expertise in procurement. And so you know you are probably the best in identifying the best recruiter that we could have in every single country. You know how important diversity is, how much we strive to have a very different series of people coming from all over. So again, each one of you counts very much. And I must say that on behalf of EBRD, the University of Rome Tor Vergata, the Master at the University of Belgrade, all the relevant stakeholders, all the chairs that have supported this program, all the speakers that did fantastic presentations. I want to thank you all. It was wonderful to see each other. It's wonderful that so many have remained here to debate until the second day. We have been honored of your presence here, but after lunch, for us, I am sorry to say, this is our job. Maybe there's an even more important moment, which is the moment of the arrivederci and the moment of the rewards for these fantastic 2 generations in Belgrade and Rome that have flattered us with their presence in our universities. And so for us, it's a very important moment. So if you don't have other relevant engagement, certainly all the students have to stay here. But please stay around because it's a wonderful moment of celebration and joy of what we do and how we do things all together. So thank you again on behalf of everybody. Thanks to the staff. Thanks to Simona. Thanks to Maria Cristina. Thank you for all the people who have supported the organization. You've done a fantastic job, and I know how much you have worked hard. I repeat it for the past months at night, all the time. Thank you, Annalisa, for a wonderful job. And I think it's time for lunch. So thank you.